Registering your birth and applying for a social security number enters you into a contract that makes you collateral for a staggering $36 trillion national debt. You're not a free man or woman. You're a person, chattel property owned by the corporate state. Ever heard of allodial title? Back in the early US, land was owned outright. No taxes, no lords. This was essential to the sovereignty of the people, making them subject only to the law of the land owing to their absolute ownership rights over it. But now, property taxes have turned your home into a feudal plot, with you as a tenant and the corporate state as the feudal lord. And your birth certificate? It's not just proof of your existence. It's a warehouse receipt, with the state holding you as chattel property and collateral for the public debt. The 14th Amendment created for the first time a federal citizen as distinct from that of the states, creating for the government a feudal subject with absolute control of its estate, your land, labor, and even your future. Your social security number ties your land, automobile, and other important property to the public debt, which you merely hold in trust as collateral, and which these banks pretending to be courts can use to generate revenue. Voter registration is another contractual nexus the corporate state uses to acquire consent for 14th Amendment citizenship. They acquire administrative control of your estate in exchange for your ability to give an opinion, and only an opinion, on who the next CEO is. The corporation, being lifeless, cannot attain parity with living men and women. So they create a character for you, your name in all caps on documents representing a lifeless legal fiction, allowing them to interact and contract with you. It is a fictional persona which the corporate state requires you to adopt for the purpose acquiring in rem jurisdiction over you as chattel property of a decedent estate. And now, with AI surveillance, your every move is monitored and tied to your legal fiction, locking you into this neo-feudal trap forever. Companies like Palantir use AI to create a detailed profile analysis of you in order to predict your reaction to stimuli and better engineer you by controlling what you see through suggested "for you" algorithms on social media websites. We must wake up and change course before we end up trapped in a closed-loop digital system, forever tied to the creature of the corporate state in an artificial world of megalomaniacs and make-believe rules. Learn more by searching Burn the Corporate Fiction on YouTube, Rumble, Facebook, and X.
Well, that about sums it up. How's that for a red pill? That is the entire trust indenture scheme in a nutshell. And that is exactly how they can enforce revenue codes like the motor vehicle code against you. All right. So, well, good evening, ladies and gentlemen. Welcome to Burn the Corporate Fiction. Tonight, we are going to continue going through the right to travel binder, the documents that you will need, that you should have, and most importantly, that you should know how to use and explain either on the side of the road or in a courtroom, right? And you have to be adaptable. You have to be adaptable to the varying degree of egotism that the officer may have or the judge. Some may be more amicable. They might be willing to hear you out and learn. And then others might just want to, empty a magazine into you because you won't give them your identification, legal entity identification. So, but before we get into this, say what's up to, we got Pat, LJ, and Mojo over in the chat, with several others watching. And then backstage, I have my fellow jurist, Jeff. How are you doing?
Doing very well. Thank you, sir.
Fantastic. That's good. I hope Mojo's rib's doing better. I hope your rib is doing better there, brother, man. No, that sucks. So, all right. Well, while we wait for some people to enter, I wonder if I'm going to get a copyright for this. I doubt it. There's a couple of videos I want to show you guys. This was interesting. It's a dub over of Rick and Morty, and it's actually spot on. It's pretty good. Since we are going to talk a little bit about trust today, because it's one of the best ways to keep your property safe. The Private Express Trust will aid you in your right to travel endeavors, and particularly when you know how to explain why that works also. Let me share this with the audience here. All right, so no whammy, no copyright. Come on. Since it's a dub, I highly doubt that it would copyright, but let's give it a shot. Okay, we gotta refresh.
Way of doing even exchanges and fair deals. And so they create things like acquisitions, all right? And so if you go to the Bill of Exchange Act that was adopted in 1882 in the United States, it actually shows you how to do consumer credit extensions, consumer credit grants, and consumer credit exchanges. And it shows you how to structure your document, and it shows you how to do the notary protest when they're in dishonor. See, they got everybody blindsided with the UCC, which talks all about commercial because they want you in commerce. They want you in commerce. They don't want you to read the Bill of Exchange Act of 1882, okay? But the Bill of Exchange Act of 1882, when you get down to the bottom of it, straight up tells you about consumer transactions and exactly how it has to be. And the words that are very peculiar and unique in the Bill of Exchange Act, for example, is given for a patent right. See?
Yeah, very, very interesting. They do want
a uniform way.
Let's stop that. They need you trapped in commerce. They need you trapped in commerce because that is the only place that Congress has jurisdiction under Article 1, Section 8. They need you to be a 14th Amendment citizen, right? Why? Because, and we're going to kind of recap what we went over on the last stream and pick up where we left off. They need you to be a 14th Amendment citizen because the people are antecedent, meaning coming before and above the government. We created the government, both the state, well, we created the state government, which is, and all government is a form of a trust. We created that to serve us. Chisholm v. Georgia tells you that the government stands in the same relation to the people as a regent would to the sovereignty of Europe. They are beneath us. They serve us. They cannot just bring up charges against us. They cannot pretend to be a victim for pretended offense or for not paying them for permission to use our property. They cannot do that, right? So the people created the state. The states got together and created the federal government, quite literally to circumvent your sovereignty ultimately. That's why the Constitution was replaced the Articles of Confederation, created a stronger federal government, and gave the judicial branch the ability to usurp the sovereignty of the states, as Thomas Jefferson said. It will work like gravity by night and by day. Yeah, I know gravity, whatever, but by night and by day to usurp the sovereignty of the states. And that is exactly what happened, right? And the back door that allowed that was the 14th Amendment. So people created the state. The states got together and created the federal trust, the feudal trust. And then that feudal trust created its own creature called the 14th Amendment citizen. In the wake of the Civil War, right, for the newly freed slaves who were not independent and could not exercise unalienable rights, one, because they had been private property, and two, because they had no idea how to be self-sufficient, which is absolutely necessary for you to be sovereign. And under common laws, you have to be self-sufficient, independent. You cannot rely on anyone or anything for your estate's survival. And if you do, the degree to which you depend on that entity or individual, you have to also conform to their will. And that's how they get you. This is a principle of common law. That's why accepting benefits, you'll hear people like me, or like we watched Derek Gonzalez last time we were on here, where he says, I've never accepted any benefits from the state. There's a very specific reason that we say that, because benefits indenture you. Okay. So the newly freed slaves could not exercise unalienable rights. Therefore, they required privileges and immunities granted by Congress, which can also be taken away by federal Congress. Black's Law 1868 says the 14th Amendment created, or at least recognized for the first time, a citizen of the United States as distinct from that of the states. We will take a look at that just to recap. right here, 14th Amendment. It became part of the Organic Law July 28th, 1868, and its importance entitles it to special mention. Creates or at least recognizes for the first time a citizen of the United States as distinct from that of the states. Very important to understand, because when you read the 14th Amendment, which I don't know if right here, the very first line says all persons born or naturalized in the United States and subject. The people are not subjects. That word subject means subject. You are a subject to the United States Corporation. The newly freed slaves became public chattel. They went from being private chattel to public chattel. Congress absolutely needed their own class of citizen so that they could use them as collateral, as capital stock, to borrow against from a third-party central banking cartel. This had been the plan the entire time. We further prove that right here when we go to Section 4, and it tells you that the validity of the public debt of the United States shall not be questioned. What does that have to do with granting equal protection to newly freed slaves? What does that have to do with it? No, it's in there because they never cared about protecting the newly freed slaves. They wanted public chattel. They wanted their own pool of collateral to borrow against, which is exactly what they did in 1933, where on page 83 of the House Congressional Record, March 9th, it tells you that the money will be worth 100 cents on the dollar, and it's only on the left side of the divider, by the way, but the money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. So they mortgaged the right, the estates of their public chattel, which is essentially your right to property, your ability to hold and enjoy property, has been mortgaged, meaning all property that you acquire as a 14th Amendment citizen is going to be held in trust, attached to your Social Security number, and used as collateral for the public debt. That's a fact. All right. Now we go over to, not farm, we go over to the law of mortgages, right? Which I believe this is West's Encyclopedia of American Law. Right here, this definition is 12th edition, and it tells you that the lender, when something is mortgaged, the person who lends money in exchange for the mortgage property, right, is entitled to not only payments of interest, here I'll highlight it, not only payments of interest on the debt, but also to rents and profits of the real estate. That is what revenue code is. That is what property tax is. That is what income tax is. That is what the fining and feeing you for the misuse of your property, requiring a license to hunt, requiring a license to fish, requiring a license to travel in your own personal property. This is a way for the money lenders, right, to have beneficial use of the property, to have the rents and the profits of your estate while the mortgage is outstanding, continues to be outstanding. This is so important. Now, some of you may be saying, oh, well, it says just the homes and other property. This means estate. And we have Fiduciary Foundations of Administrative Law by Evan J. Criddle, UCLA law student, UCLA Law Review. And he admits right in this paper that he wrote that the emerging fiduciary model and administrative law. Now, what is administrative law? Administrative law is the administration of property that has essentially been taken under guardianship. It's called taken under administration. And basically, it's just regulating the use of property held in trust. That's what administration means. The word administration always has to do with trusts. Okay. And the administrative law is the regulation of the use of property that's held in trust as collateral. That's why he's calling it the fiduciary model. A fiduciary is a trustee who can make financial decisions. Okay. So the fiduciary model of administrative law, essentially it's a lawyery way of saying generating revenue from property that's under administration, right? And he tells you, posits that administrative agencies, what are administrative agencies? The DMV, the ATF, right? All of these licensing bureaus, right? Down in Virginia, they've got an alcohol administrative agency just specifically for alcohol. It's called Alcohol Beverage Control, ABC. You actually have to go to government-sponsored, government-owned stores to purchase liquor down south, right? And this is administration. That's an administrative agency. So it tells you that administrative law posits that administrative agencies are endowed with authority to set regulatory policy. This is public policy. This is why they no longer call it public law. It used to be, prior to the Civil War, called public law. Now it's called public policy. Okay? And regulatory policy is exactly that. It is making rules regarding the use of property that is held in trust and used as collateral. That's what all these quote unquote laws are. They're not laws. Okay? They're regulatory. Go ahead.
Oh, yeah, I was going to say, I've noticed three references to law that are not actually law in the documents you just read. And they're only law to a persona, the Ensley, just the character that they produce. They're not law to a free man.
Right. They're law to the contracting parties, to the parties who've consented to the contract making the law. Right. So regulatory policy. Oh, go ahead. Yeah.
I was just thinking to myself, the very person they call into court. They're not calling the man. They're calling you as a representative of the Susquehanna Trust at all.
Right. They need to place you in rem jurisdiction. In rem jurisdiction, which is the jurisdiction of things like chattel property, anything dealt with, like if you had servants or slaves or something like that, and you had to go enforce something in court, right? It would be an in rem jurisdiction because you're dealing with property. Or if they wanted to enforce something against chattel property, slaves or indentures, it would be done in rem. And so they're bringing you in rem. The government itself, and especially now that it's a private for-profit corporation, according to Dun & Bradstreet, with its own Dun & Bradstreet number, it is a artificial construct of the mind. It has no existence in fact. It cannot attain parity with the people. What does parity mean? It means it cannot be on the same standing as living men and women at law. It cannot have the same standing at law as living men and women. So what do? They create this persona for you, this 14th Amendment indenture, this 14th Amendment infant that's under administration, and then they cause you to adopt that persona. So now you're adopting an artificial construct, a legal fiction, a dead creature, right? And you adopt that, and now they can deal with you. Now they can contract with you. Now they can regulate your property. Now they can do everything they needed to do, which they can trump up and say, oh, you didn't pay us for permission to, use this vehicle or use your property. So let's look at it like this. And I went over this last time, but it's a great example. What are they doing when they pull you over for not having a license plate? What is a license plate? Right? It's commercial. Go ahead.
No, I was just going to say they're attempting to make an attachment to your
trust,
your estate, your trust. Yeah. That's all they're trying to do. Generate revenue.
Which really
is, and
this is an important thing to understand, especially to comprehend, however you want to say it, right? Especially given like people try to cash in on it. That trust that was created, that Social Security underwriting investment trust, that is not yours. They made that. It's theirs, right? Now they use your sweat equity as surety, but that entire thing from start to finish is their creature, right? You don't want to take over their trust. You don't want to, be able to discharge, like people say you can accept for value. They'll never do that because it's their creature. They made it. They created it. They control it. Because remember, the creator controls the created, right? And the created can never control the creator. They created the 14th Amendment citizen. They created that Social Security trust. So it's absolutely essential that you remove jurisdiction by removing the presumption that you are a 14th Amendment citizen. Because so it tells you right here. So they set regulatory policy. Regulatory policy is regulating the use of property held in trust. So the property you think is yours, they do not look at it like it's yours. You're entrusted with the maintenance of it and the performance of obligations placed on the property in the estate, right? but it's not actually yours, and you get charged a fee for the use of it, right? To use the estate to make money, like say in employment, in the employment scheme, which is a ploy, right? It's a ploy, it's a scheme. And in the employment scheme, they're going to charge you a fee for using an estate that they're administering to make money, and that's income tax, right? And then they're going to fine and fee you for the misuse of it as well. All right, let's move on. So, regulatory policy: when Congress and the president acting jointly as proxy settlers. Okay, so we're going to go over what is a settler, what is settlement. Settlement in contracts, the conveyance of an estate for the benefit of some person or persons. So right here, they're telling you it represents a mortgage on all the homes and other property of all the people in the nation. They settled your estate, and that's what is being admitted and the fiduciary foundations of administrative law right here, acting jointly as proxy settlers for the sovereign people. Okay. Good evening, Theo. I see you over there, man. So
they could only do that because we were not present. That's why they were proxy settlers, because we never claimed our estate. Am I right on that?
Sort of. So the reason they were proxy settlers is because the United States citizen, the 14th Amendment citizen, is considered essentially under the guardianship or parentage of the federal corporation. Sure. So the federal corporation can make decisions like that for the benefit of the wards under its charge, basically. They have that essentially power of attorney, if you will, that ability to through probate, through an established principle in probate, where they can grant licenses for the sale of any portion of an estate or the entire estate if it's for the benefit of the person under administration. So when you accept those privileges and immunities, which the newly freed slaves needed because they did not have the inherent rights that come with independent sovereign people who know how to, they just had all of their material needs taken care of for them for generation after generation while, they labored in exchange as slaves, right? So they could not be self-sufficient in society and have their unalienable inherent rights that come with self-sufficiency, according to, and just so we can get this out of the way, we're covering the same ground again, as Blackstone's commentary. He tells you, let's just get to the point of it. It says, but a state of dependency will inevitably oblige the inferior to take the will of him on who he depends as the rule of his conduct. And so the 14th Amendment citizen owes its entire existence and all of its privileges, immunities, and benefits to the federal corporation, right? Is a creature in the same way that God made man and woman, right? The federal corporation created the 14th Amendment citizen. That thing exists as an extension of the federal corporation. So anyone who accepts those privileges, immunities, and benefits, that status of being under the parentage of the federal corporation, automatically takes on the will as the rule, takes on the will of the federal corporation as the rule of your conduct. And that's why they were able to do that. Jeff.
Yeah, I got it.
Does that make sense? So,
absolutely, yes. Until you claim it on record, and then you can free yourself from that. Now, I looked at the slave thing, kind of like, since we're talking about automobiles, there's a parallel there, because you, as the owner of that vehicle, you are required to maintain it, keep it fueled up, and that's just like taking care of it. And what does it do? When you step on the gas pedal, it goes. So it's your slave. I can see where a vehicle would be looked at as my slave than when I'm driving it.
Yeah,
it's
and
kind of the same thing.
The biggest thing is the legal operation, what happens when you register something. So as soon as you register something, you give the controlling interest of the property being registered over to whomever you're registering it with. You're literally, registers means to give to the crown, essentially, etymologically. Regis, regal, crown, right? So you're registering something, you're essentially giving it to the crown. And the reason people historically, going all the way back to William the Conqueror, have registered things is for protection of the property. But you also give the controlling interest of the property over to whomever's protecting it. So when you register your car, right, and this is actually how registration started. It was called the Vehicle Theft Prevention Act. And the Vehicle Theft Prevention Act was basically like, hey, you can register your car with us and we'll assign it, in a number, identifying numbers, all this stuff. And then if it ever gets stolen, we can help you find it. And it says right in the Vehicle Theft Prevention Act that it was voluntary. It's voluntary to enter into this program. But once you do enter into it, much like income tax or anything else, and it requires auto renewal. And eventually that became part of the motor vehicle code to force you to register it and auto renew it. And that's because you cannot actually buy anything. You can only purchase with negotiable instruments that carry liens, attachments, right? That require anything purchased with it be used as collateral via registration. So it's the registering. Anything that you register, you're giving the controlling interest over. You register your children as biological property. You give the controlling interest to the state because that's who you're registering it with, or the county, right? So that's an important thing to understand also. And at the same time, so the 14th Amendment was ratified at gunpoint in 1868, quite unlawfully, right? With 15 out of 37 of the states then in the Union voting against it, which is nowhere near the 3/4 majority. And we can get into that a little bit later. You're going to want to keep that document with you also, where it shows you the 14th Amendment is unconstitutional, was never lawfully ratified. You want to keep that, have that.
Congressional record in 1967 states
1967. Yep, June 13th. I have it pulled up here as well. So you want to destroy the presumption that you're a 14th Amendment citizen, because all of this revenue code, this rents and profits from the property that's being held in trust as collateral, can only ever apply to 14th Amendment citizens. That's the only people, the only entity that it can apply to, subject to Congress, right? And liable for the debt of Congress. So this is what you're trying to convey to the road pirate on the side of the road, and what you are conveying to the court. And you're not asking them, you're telling them, right, that I am not a 14th Amendment citizen under administration. So you will actually be committing a crime against me, right? And you need to be able to prove it. So I had this guy commenting, which hopefully he comes up on panel, because I told him, come up here and I'll make you look stupid. And he's like, oh, you are a U.S. citizen. Like, no, you're not a United States citizen. Well, sometimes people got confused before the 14th Amendment, but after, everybody's a U.S. citizen. No, you're not. All the way up until 1922, not everybody was a U.S. citizen. That's Long v. Rasmussen. When IRS tried to distrain this lady's property for taxes, she took him to a court of equity and beat the guy personally because she was a non-taxpayer. She was not a federal chattel, right? And so she won that case. And right here we have McDonald v. State from 1883, May 15th. And you go down and it says the evidence of bushing on his voir dire, which is what they used to see the fitness of a juror, showed that although he was not a citizen of the United States, he was a citizen and voter of the state. Under Section 2 of Article 2 of our state constitution, one may be a citizen of a state and yet not a citizen of the United States. Now, this wasn't unique to Indiana. This is everywhere.
And
most police officers had...
The other citations, Thomason versus State, are those backing it up too? Corey versus Carter?
Yes.
I'm sure they were already there, right?
Yep, Thomason v. State. These are other cases where they use that as the precedent to be able to make this statement. That's why they cited after a Thomas v. State, Corey v. Carter. There's all Indiana Supreme Court cases. You want this case, okay? You want this case. You want to highlight this specific section right here and prove, right? Prove that 14th Amendment citizenship is voluntary and did not always exist, right? So just to recap, you want March 9th, 1933, House Congressional Record, page 83. Just print this page off by itself. Highlight this right here where it says the money will be worth 100 cents on the dollar because it's backed by the credit of the nation. It represents a mortgage and all the homes and other property of all the people in the nation. That's why they're able to apply revenue code to your automobile, because you as a 14th Amendment citizen, your sole purpose of residency in the state, because a resident is a resident alien, is a foreigner. Your sole purpose of being in the state is to engage in a commercial enterprise on behalf of your daddy government back in DC, right? Your federal government. And that's the whole, it's one big commercial scheme. It's one big federal tax plantation, for lack of a better term. And so the presumption automatically is, if you have an ID and you establish that you're legally present in the United States territorial jurisdiction, that you are engaged in commerce. There is no saying, well, I'm traveling, I'm not driving, or not. If you're a 14th Amendment citizen, you're engaged in commerce. That is the sole purpose of your residency, is to be engaged in commerce. And make no mistake, you are a foreigner. Right here, we've got this good treatise, elementary law. I also have printed this page out, right? That shows you the members of a state. A member of a state may either be a citizen occupying the status entitled citizenship, or he may be a resident alien occupying the status designated by the title residence. A citizen is a permanent member of the state, right? And is titled to his permanent protection, etc., right? So the status of his membership, citizenship, is distinguished by its permanent and personal nature, and may be determined by the place of his birth or the nationality of his parents. Now, as distinguished by a resident alien, or distinguished from a resident alien, on the other hand, is a person residing within a state other than the state of which he is a citizen. He owes the state of his sojourn allegiance and is entitled to its protection during his stay. The status of his membership, residence, is distinguished by its temporary and local nature. When you are a 14th Amendment citizen, you are a resident of the state, meaning you're a resident alien, and the sole purpose of your residency is to engage in commerce on behalf of your parent, on behalf of daddy government back in DC, right? Absolutely, that's what's going on here. So you've got, let's see.
So that's kind of like what you've said 100 times. No governor will call you a citizen of the state of Texas. He'll call you a resident of the state of Texas.
Ever, exactly.
Yeah.
Yep. So you're always Michigan residents, Virginia residents, Texas residents, never citizens anymore. But that is what you are. That's your nationality. It's your birthright. Now here I've got this UCC 9-307. You can print this out where it shows you the location of the United States. The United States is located in the District of Columbia. So this is called location of debtor, UCC 9-307. The United States is the debtor. You, as a 14th Amendment citizen, are an agent of the debtor. Therefore, you're charged with performing the obligations placed on the debtor or debtor estate, right? So it's located in the District of Columbia. Now, I want to show you guys something real quick. Let's see if I can find this. Residents, since we're talking about how residents are resident aliens, you want to be able to prove this to the road pirate. You have to be able to prove this. You have to know what you're talking about. It doesn't mean they're always going to listen, but once you get to court and you know how to explain this stuff, you create a massive problem for them, because they will not be able to move past go. They will not be able to arraign you and obtain equity jurisdiction over you to enforce the trust. They're not going to be able to do that when you know how to explain this, what they're doing to them in front of everybody in court. So resident defined in Michigan Motor Vehicle Code. Now this is very curious wording here that's used.
Can I add to that last statement?
Of course.
Also, rather than relying on the clerk recorder or whatever she's called, for her bring your own form of recording, so you have your own recorder when you go into court and you're trying to establish jurisdiction over you. Yeah.
Absolutely, always record your own interactions. Yes, because their record, as Mojo in the chat knows, will not. They will not keep a record. They'll alter their records and they can, because they're they're private courts. They're private courts. They can do whatever they want. So, all right, resident in the Michigan Motor Vehicle Code. Resident means every person who resides, remember that means you're a foreigner, resides in this state and establishes that he or she is legally present in the United States. Those are two different places. The state and the United States are foreign to one another. So what they're saying is, though you're living here, right, you're residing here temporarily, it's a temporary status, right? you're legally present in the territorial jurisdiction of the United States. The United States is foreign to the state. So we go over here and look, this is the only place that the United States can physically exist. Jurisdiction is right here in these 10 square miles that we caged in with boundary stones to mark that's where they have jurisdiction. Because on one side of the stone, it says jurisdiction of the United States. And on the other side, it says Maryland. So when you're heading in here, now you're under the territorial jurisdiction of the federal corporation. And then when you go back here, you're back under common law. Back in Maryland, you're back under common law. And we literally cage this beast in. This is another thing I print and I have just to show, right, that we literally cage this monster in.
I got a question about that. Is that why that's the only claims court in the United States is in Washington, D.C.?
More than likely, yeah. So this right here, this is important. So now you should be able to read this as a lawyer would, right? So resident means every person who resides in the state and establishes that he or she is legally present in the United States. Every word of that is chosen carefully. And how do you establish something? By compact. That's why we said, we the people do hereby ordain and establish. That's to create law. That's to create a contract, a compact, right? So to establish is referring to contracting into being legally present in the United States. Because, once again, just in case you missed it or you're just now tuning in, right? That's negotiable instrument. This one. Location of the United States. The United States is located in the District of Columbia, right? Go back to McDonald v. State. One may be a citizen. One may be a citizen of a state and yet not a citizen of the United States. They're two different statuses, right? And one is public chattel, can never operate in the private because by the very virtue of the 14th Amendment being essentially protected by Congress and granted privileges and immunities, you are public property, you're public chattel. So you can never operate in the private. Like that's what you want to do in order to assert your sovereignty and be able to enforce your common law rights to property, right? You can't do that as a U.S. citizen because you're public chattel. You're a trustee of your own estate, but they don't even look at it like it's your estate, right? You're just a trustee of a decedent estate. That means the heir or the owner of the estate is missing, presumed dead. That's how they list you in the IRS tax code, decedent estate, right? And they have to under the Set the KB Act. Otherwise, they would have to compensate you for the use of your property as one of we the people. But when you're just the public chattel and that's the only aspect of you they recognize, then you're a creature of the corporation. You exist at the mercy of the corporation and you're subject to the arbitrary whims of the legislature, which is what creates public policy regulating the use of your property, right? So just basically look at it like you're a child. Okay, now here's another one that I print, and I'm surprised I don't actually have it up already, but we want to do one, whoops, that was an exclamation point, 1 USC 8. Now, this is very, very important. This tells you exactly who the U.S. citizen is. The 14th Amendment citizen is an infant, which means incapable of holding property, right? I've actually got this thing from AmJur, which I can't share on the screen because it's on my phone, but I'll read it to you guys because it's very important, which is American jurisprudence. That's what AmJur is, right? And it tells you that it's federal authority. It's section 12 from 42 American jurisprudence 2D infants section 12. Okay. And it tells you that the federal government does not stand in the position of parens patriae, which means government as parents, with reference to the person and property of infants, except for those in the territories and the District of Columbia. Now, an infant is somebody who's under administration, somebody who's legally incapacitated. Okay, you can call them other things, non-compos mentis, or they could be a drunkard, a spendthrift, whatever. But what they've done is they've reduced the United States, the 14th Amendment citizen, to an infant. And they define it here. This is right in the very first title of the U.S. Code, Section 8. Okay, person, human being, child, and individual, as including born alive infant. This is important. In determining the meaning of any act of Congress, meaning anything that they've legislated, or of any ruling, regulation, or interpretation of the various administrative, regulating your property, DMV, etc., right, bureaus and agencies of the United States, the word person, human being, child, and individual shall include, right, meaning at the exclusion of everything else, shall include every infant member of the species Homo sapiens who is born alive at any stage of development, meaning you can be a 50-year-old infant, okay? But now the word include is very important in statutory construction. When you include something, it's at the exclusion of everything else. That means for any act of Congress or any ruling, interpretation, blah, 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 right? Whenever you see the words person, human being, child, and individual, it means infant. That's it. Nothing else. It just means infant. And infants cannot hold title. Infants come under the federal corporation under parens patriae, or government as parent, right? Or parent of the country, more accurately. And that's why they can make these decisions for you, like mortgaging your property, telling you how to use your property, and indenturing you. They can make those decisions because in the same way that you can make decisions regarding your child's estate, right? That's what they do for everybody. So I print this as well. I keep this with me, and this stuff. And at the end of these streams, when going through explaining this stuff, I'm going to put together, I'm debating on whether or not to put together a physical binder or just a PDF version, right? One or the other, that's going to have all of these documents in it available to print, right? So you've got to have all of these. The McDonald v. State, very important, dude. Tells you that you do not have, you're not bound to be a citizen of the United States. The Motor Vehicle Code for Michigan, saying that in order for me to be a resident, right? Because as something you say to the cop, you presume that I'm a resident of Michigan, right? Well, I'm one of the people of Michigan. A resident is a resident alien or a foreigner, right? So you reside in this state as a resident alien, but you establish, meaning via contract agreement, you establish that you're legally present in the United States, because you cannot be physically present in the United States unless you're in the District of Columbia or a federal territory. When you're in the state, you're one of the people of the state unless you agree to be under the territorial jurisdiction of the United States, meaning you're abroad from your home, which is the District of Columbia, and you're here to do business and engage in commerce. So everything you do, no matter what, even if you're just driving to the park or, traveling to the park, whatever you want to try to tell the cop, if you've got commercial advertising on the back of your car that's got a license plate number, it's a license plate number attached to your Social Security trust, then you are engaged in commerce. And that's how they look at it. And they're going to go ahead and create an attachment and fine and fee you for the use and the misuse of your property. Right? So you keep, and every state will have a definition similar to this, right? Where it'll say something tricky, where it's like you establish that you're legally present in the United States, right? So you're going to want to print that out. You're going to want to print the congressional record, this about the law of mortgages.
On the last thing, something that I know, but maybe some of the listeners don't know, is the document of equal footing, to where any law that is,
it's right here
in one state. You were probably going to get to that, weren't you?
No, it's actually right here. It's so it's Article 4, Section 2 of the Constitution. This is the other place where citizens are mentioned in the Constitution, right? As far as what they're entitled to. And these citizens are not the same as the 14th Amendment citizens. These Article 4, Section 2 citizens are the people of the several states under common law. And so the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. So whatever is available in one state is available in all states. So when you look at, like, which this is another one you want to have as soon as I find it right here. It's Wisconsin Constitution. Okay, this is the original 1848 Wisconsin Constitution. It's Article 1. You go down to Section 14, and it says, all lands within the state are declared to be allodial, and feudal tenures are prohibited, right? Then why do you pay property tax, right? Because Article 4, Section 2 says that this applies, of the federal Constitution says that this applies to all states. You have the allodial right to land in all states. Well, when you have an allodial title, there's nobody above you, meaning nobody can fine or fee you for the use or misuse of the property. So what is property tax? See, they circumvented that via the 14th Amendment. They circumvented this ban on feudal tenures by just establishing an artificial facsimile of our original system parallel to our original system, and then pulling everybody out of the de jure into the de facto via contract and presumption. And now they're just operating this de facto system as if it was the original, when really they're violating the fundamental law of the country and establishing feudal tenures. What does that mean? It means the county surveyed and appraised the land and has it in a registry, and that you have to pay the county property taxes every year to continue living on that land because you don't actually own it. You're just a tenant holding the land in trust, right, as an agent of the debtor, the federal corporation. And therefore, the property that you're holding, because you cannot buy anything, gold and silver, right, you purchase with negotiable instruments. Anything you purchase with the Federal Reserve contracts have liens on it, automatically come with strings attached, because you didn't actually buy it. So the obligations that are contained in that contract are transferred to the property purchased with the contract, using the contract, the commercial paper. And so that's how they've circumvented this ban right here on feudal tenures. And yeah, anyway. So another case that you need to have is Chisholm v. Georgia. Again, we're still kind of recapping, right? So Chisholm v. Georgia says, well, what I usually do is, this whole thing is about the sovereignty of the citizens of the states and sovereignties of the states themselves over the federal corporation. So what I do is I do this and I say sovereignty devolved. So there we go. That takes me right where I want. So sovereignty devolved. It says, at the revolution, the sovereignty devolved on the people, and they are truly the sovereigns of this country, but they are sovereigns without subjects, unless the African slaves among us may be so called, and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. So it goes down and explains the difference between a feudal sovereignty of Europe, right, where the king or the monarch is the supreme property holder, the controlling interest of the property. And so he gets to create administrative law by regulating the use of all the land and property within his domain. And that's the only way he can make law, because man cannot make law, right? Law can only be written about, cannot be written, right? Only God makes law. It's a fact. Okay. So in order for man to usurp that authority, to be able to just arbitrarily make law for an entire nation, they must bring that entire nation under administration, or the property of that entire nation under administration, under administrative control. So then they can regulate the use of it, because they have the superior interest in the property. That is the only way that they can do that. And that's what this guy explains right here. He says, in Europe, the sovereignty is generally ascribed to the prince. Here it rests with the people. There, the sovereign actually there's the word administers the government. Here, never in a single instance. Our governors are the agents of the people, and at most stand in the same relation to their sovereign, meaning us, we the people, in which the regents in Europe stand to their sovereigns, meaning our government is subject to us, right? Unless you adopt the 14th Amendment citizenship, and then you become subject to the jurisdiction of the federal corporation, right? But if you're one of we the people, then the government is basically the equivalent of a regent in Europe, stand to their sovereigns, right? So they're subject to you. Got to have this case. This case enshrines our original standing, the sovereignty of the people, truly above the government, like they try to say is a conspiracy theory. Absolutely is not. It absolutely is not a conspiracy theory, okay? This is our original standing above, and it just, if you know how law works and you know how common law works, it would stand to reason. The only way that you could become subject to the creature, right, is if you adopt a persona or a creature of that creature. or if you become indebted to the creature for your survival, as in the case with paupers. That's how they take paupers under administration, because the state goes, well, you couldn't live without us. You cannot make your own estate productive, right? So you're coming to us for welfare. So we're going to take your estate and we're going to administer it and we're going to make it profitable, which means you're going to do what we tell you to do with your body and your property, and we're going to make you profitable. And then we'll give you a portion of that profit in the form of benefits. And that's where the whole settlement acts and the workhouses and all that stuff came from. That's what the church was doing with the poor, was taking them under administration, forcing them to work in workhouses in order to make themselves productive, and then giving a snippet of their productivity back to them in the form of a benefit or benefits, food, clothing, shelter, whatever. And then, of course, keeping a handsome profit for themselves, might I add, because why not, right? Isn't that just charitable and philanthropic? They're philanthropaths, right? Psychopaths who use philanthropy to be psychopaths. They're philanthropaths. And that's what the whole system is made up of. So, all right. Got that. This, obviously, you want this fiduciary foundations of administrative law as well. And you want to know how to explain this. You need to know what settlement means. Proxy settler for the sovereign people. What does it mean when Congress and the president acted jointly as proxy settlers for the sovereign people? What does that mean, right? Settlement, the conveyance, meaning the giving or transferring of an estate for the benefit of some person or persons. So that is exactly what they did here when they say they mortgaged, right here, they tell you they mortgaged all the homes and other property of all the people in the nation. That's called settlement. They conveyed your estate for the benefit of being able to engage in commerce, right? So your estate, your sweat equity, your productive value is held in trust and used to back the Federal Reserve notes that are in circulation, because they are inherently worthless without your productive value to secure them, right? Which means that investors get a controlling interest in you, right? So that's the real allure here, is the power and control over other men and women. That's what it's all about. There actually isn't even any money in the game anymore. It's all just about the control of property and people, right? Men and women, because these people are psychopaths. They're evil. They're evil, just scummy, megalomaniac pieces of garbage, right? That all deserve the gallows. Every single one of them, right? Hopefully one day, as long as we can keep waking people up here on Burn the Corporate Fiction and other channels that are doing good work as well. So they conveyed your estate as settlement. So now you know what this means. They acted jointly as proxy settlers. They mortgaged your right to property. That's what that means. This is a fancy lawyery way of saying that they mortgaged your rights to property. Now you have no property rights. You only have equitable rights as determined by the contracts you enter to use the property. And that's the control aspect that I was talking about, that they were interested in. These administrative agencies are interested in the control. They want to control what you do, what you think, how you act, right? And they can, as long as you're under administration. See this corporation right here, this is another one you can print. This is from gov.uk. This corporation right here called the United States of America, that's labeled on Companies House, right, of gov.uk, the city of London, right? It's a commercial extension of London. It was always designed to be bankrupted. Okay, that was the intention. What they wanted to do was they set this corporation up with the express desire to ultimately pull everyone under it by creating the federal citizen, for instance, the 14th Amendment citizen, pull everybody under that corporation and then bankrupt it in order to indenture everybody and take control of their property. And then man can write law, usurp the authority of God by making administrative law, regulating the use of people's property. You can do this. And so it shows you it's got one active beneficial owner. Wonder who that is, right? And it was notified on the 3rd of July, 1776. And it's essentially, the full name is the Government of the United States of America. And it is a foreign corporation. It's a foreign agency. Not only that, but this is another one to keep handy too, is federal, wait, hold on. United States. United States defined. 28 USC section 3002. The United States means a federal corporation. Okay. Now we can do this and go United States business. This is another one that's good to have. And this is 15 USC section 4724. The term United States business means a United States citizen. Weird. No wonder corporations can be considered persons protected under the 14th Amendment, attaining parity with living men and women, because those living men and women are actually adopting a non-living persona, a business, a decedent estate, a trust company, a widely held fixed investment trust. So, hey, Mr. Obvious, we got Catch. Catch said he's going to catch the replay. Harmon Walker, sorry. Time to feed the birds, he says. All right, cool. Got a little bit of an audience this evening. So, and yeah, so right here, United States business means a United States citizen. Another good piece of information, right? So the way that they're doing this is they've created these districts, right, specifically for the purpose of generating commercial paper. They started off as land banks under the Federal Farm Loan Act. You're not going to explain all this to a cop, so I wouldn't bother printing this one out, but this is just for your information so you know what's going on. These land bank districts ultimately became the Federal Reserve districts. What they do is they take agricultural loans out against your birth certificate. Ultimately, you are considered an agricultural commodity because of what farm means in relationship to the government and politics, right? So we'll look here. It says, let's go down here. It says, farm, government, politics, and diplomacy to collect the monies due and retain profits from a tax district, business, etc. for a specified period or payment of a sum or sums. That's why they split the nation up into 12 different farms, right? To operate a franchise under similar conditions. That's what the United States citizen is. Let's see here. To English history. Okay, so the system, method, or act of collecting revenue by leasing a territory in districts, a county or district lease for the collection of revenue, a fixed yearly. So they're farming you. So long story short, they're farming you. That's what they're doing. And all of this was set up under the guise of basically protecting the farms of the country during tumultuous economic periods. But it had nothing to do with that. It was to set up their commercial paper farming scheme. And that's what I mean when I tell you that we're territorially occupied by a hostile foreign corporation. And you have to be adaptable, able to explain this in a multitude of different ways, depending on the temperament of the officer or the judge that you're dealing with. But by now, we have solidly established. Go ahead.
Oh, I was just going to ask, when were these districts laid down? Did I miss the year?
We talked about that, and the Jurist Society was 1916.
16. Okay. Oh, that's right. That's right.
Yeah, it was the Federal Farm Loan Act of 1916. So they set up the Federal Reserve 1913, and they immediately sliced the country up into 12 federal farms, 12 federal districts, for the purpose of, ultimately placing everyone under the trust indenture. After 1933, they actually did the Trust Indenture Act of 1939. This is what the actual act is called. And essentially it's to compel performance of obligations for investors and so it's funny because all of these cops, all these police departments, these municipalities, they actually have bond ratings. Their bond rating is determined by how well they enforce compliance, literally. So if a municipality has a AAA bond rating, that means that if you've got a warrant for a parking ticket out of that municipality, that municipality will drive to the other side of the state to pick you up on it. That's how. There's a couple places up here in Michigan that are like that. I'm sure LJ probably knows. You got Sergeant Frog Dog in the house. Good to see you, man. So it's a farm, right? They get a bond rating based on their ability to enforce compliance to whatever trust indentures created by the court. So we got Sarah with us. What's going on, Sarah? She said this shit gets her hyped. That's cool. All right. So we went through all those. Okay, so you established the mortgage, the bankruptcy, the mortgage, the federal citizenship, the fact that it's voluntary, right? And now the rest of this starts to get into a little bit of unfamiliar territory for the public viewers. Okay, one, this is something we teach how to do in the Jurist Society, but don't necessarily have to do it my way. You can do it however, but you've got to put on the public record, you've got to claim your estate. So right now what's happening is this estate, you as one of we the people are presumed missing, or missing presumed dead. They have to do that. That's why they only ever call you a resident of your state. They'll never call you a citizen of your state. A resident is a resident alien, a foreigner. And the reason that you must necessarily never be a state citizen to them is because then they would owe you money for appropriating your property, your rights to property, and mortgaging them, because they could never do that to we the people who are before and who come before and are above government. They could never do that to we the people. They can do that to their public chattel, to their federal personnel receiving deferred retirement benefits in the form of Social Security, Medicaid, Medicare, all that stuff. So they would owe you money if you were one of we the people. So you necessarily, as one of we the people, to them, you're a decedent, which means missing, presumed dead. Your status is unknown, but you're presumed dead. So they call you decedent. Okay. And because you died or you went missing without a last will and testament, by operation of law under the Magna Carta and pretty much the entire history of English common law from the Magna Carta onward, if you die intestate or you go missing intestate, which means without a will, then automatically by operation of law, a special administrator is appointed by the court, and they take administrative control of your property. So that's another reason why they need you missing, presumed dead, or decedent, so they can take control of your property, right? Just by presumption, just by there's no will, the heir and the owner is missing, presumed dead. All we have is this federal infant here, this public chattel that we have maintaining the estate for us. We're taking it under administration. Boom. Automatically, since you're automatically an infant under Title I, Section 8 of the United States Code, person, human being, individual all means born alive infant at any stage of development. Infants are incapable of holding title, and infants do what their daddy tells them to. And that's what the public policy is directing the use of property by infants. So these are the presumptions you're up against, primarily, among others. And, then there's also the fact that you're a pauper. You have no access to lawful money, meaning gold or silver, right? So therefore, you're poor, you're a pauper, and you come under the Settlement Act and the English Poor Laws automatically. And the state is able to take administrative control of your property because you're a pauper. So you're a charge to the state. You need benefits. You need welfare. You need help because you can't take care of yourself, right? You need the benefit of being able to use Federal Reserve notes to engage in pretend monopoly commerce. And that's a benefit, right? So these presumptions. Yep.
Can I ask a question? Okay. I did purchase some silver a few years ago, and I know possession's 9/10 the law, and it's in my possession. I don't have it stored anywhere. I have it. And do you think they're going to come try to confiscate it? I guess is what
Your
I'm getting
silver?
to. Yeah.
No.
Okay.
No.
So I can be considered a pauper because I do have quite a bit of stuff.
You're still considered a pauper, because what they did is trickier than that. They made it illegal under their territorial occupation to use gold and silver as legal tender in the payment of debts, in direct violation of the federal Constitution, Article 1, Section 10. And so because they only accept commercial paper debt securities as currency, as legal tender, they have effectively, that's why I told you, we put in our claim, any use of the Federal Reserve notes or anything tied to the Social Security Trust is done under duress and without prejudice, because society has been engineered as such to make it so that you cannot exercise your unalienable natural rights without at least sometimes using Federal Reserve notes, because they've literally made it the only acceptable form of payment, which it's not even a payment, it's just purchasing. It's negotiable instruments. You're not buying or selling anything. You're just exchanging equitable titles and contracts. That's all you're doing in this country. There's no money. So Sergeant Frog Dog says he carries a $20 silver coin in his pocket at all times. And that's because anything $20 or more places you in the common law jurisdiction, according to the Constitution. So yes, very smart. What's up, Scott? New York City. Good to see you. We got Dick Wayne. He says, I'm in Canada. I typed the numbers on the back of my birth certificate into some website, can't recall which, many years ago, and there was a dollar amount attached to it. What does that mean? So they take out agricultural liens against your birth certificate. Your birth certificate is considered biological property, or represents the title to biological property. And because they've divvied up, as I'm showing here on the screen, the definition of farm is a system, method, or act of collecting revenue by leasing a territory in districts. That's exactly what they did in 1916. And even if you're in Canada, they did it they did the same thing. Wash, rinse, repeat. In every country, they set up the same exact system, and they have divvied your nation up into taxable districts for the purpose of generating revenue. That's part of why they're able to get a loan, an agricultural loan against you in the first place, because these investors, the lenders, are guaranteed the promise of being able to generate revenue from your property down the road, whether it be through the motor vehicle code or property tax or excise taxes of like licensing and various things like that. They're guaranteed the ability by entering you into that indenture scheme. You're a cash crop. You're literally a cash crop, and they can use you to farm commercial paper to generate securities, using you as the surety. So surety is like a guarantee for a payment of debt, like a security deposit, just call it. Right? So you are the security deposit for the public debt of your nation. That's why they took us off the gold standard here in the United States and made the Federal Reserve note the global reserve currency, so they could tie every other nation to our trust indenture scheme and allow these other nations to do the same exact thing through the central banking system in their countries that was done in ours, and enslave the people through a trust indenture, which is, you're just the trustee of your own estate with only equitable rights to your property. And in equity, the judge is God. So you can't actually stand on any lawful rights, and the judge is skewed against you. He works for the state, the cop works for the state, everybody works for the state, and they're all trying to fleece you. There's no winning. That's why the only option you have is to challenge jurisdiction. So the reason I brought all of this up originally is no problem, Dick. The reason I brought all this up is because you need to claim your estate on the record. You need to rebut. So the record is how the title to all property was affected under common law. Okay. So you were issued a land patent, say, for your land. You were issued a land patent from the state, or maybe the president, depending on if it was a federal territory. You had presidential land patents. Texas issued their own land patents. And it was a allodial title. And it would say for you and your heirs to have and hold forever. And it was called an addendum clause, right? For heirs and assigns forever. Now that land patent is basically the originator that sets the metes and bounds of this specific property, that gives this property life on paper as essentially a fiction, kind of, right? You can look at it like that, because the land patent itself just represents these imaginary boundaries that you've created to establish that this section is my property, right? Or that the state decided to create for that property. And so you have that title. Now, when you have that allodial title, that land patent, right, nobody can tell you what to do on your land. Nobody can fine or fee you for the use of your land, charge you a property tax, none of that stuff. And if anybody comes on your land unwarranted, you can deal with them however you want, so long as you give them adequate warning. You can't just outright murder them because that's a violation of common law. But if you tell them to leave and they do not, then it's whatever. So that's what having a allodial title. That's why you hear stories, if you're old enough in this country, you hear stories about farmers just, shooting trespassers and stuff like that, right? Because they just couldn't. Nobody could say anything. It's their property. They had a allodial title. It's their property. They're the king of their property. That is what living in the private is, right? The public has nothing to do with what you got going on your property, ever. It is your law. You make the law of your domicile, your property, because you are the sovereign. So, what was it? Okay, so the allodial title. So the title to property was affected on the county record. All right, and also the history of administration in England, especially. So what happened? This isn't the first time they've done this whole thing with the presuming people missing or missing presumed dead situations. Not the first time. I'm sure a lot of you know this already. The first time that they did this was way back with Emperor Nero, or at least the record that we have of Rome. Emperor Nero, who is a psychopath, with the consent of Senate, burned Rome to the ground, killing a bunch of people, and then issued the 12 tables. And in the 12 tables, it said basically, hey, since we had this big chaotic fire, we don't know who's living and who's dead anymore. In order to, not screw any kind of lessees or revisioners, people who have leased out property or who hold tenements, or control tenements as a lord, in order to not screw them over, we're just going to presume everyone's dead, and you have to come forward and prove that you're alive with an action on the record in order for us to give you your estate back. And that's what the whole Set the KV Act is about, because they did it again. So that was Emperor Nero in the 12 tables. And then later on down the road, you had the London Plague, which was like in the 1660s. And then right after the London Plague, you had the London fires, which were obviously intentionally started of 1666. Sorry, the London fires of 1666. There's some like 70,000 people were killed between those two events. And then, of course, they issued the Set the KV Act, where it said, we had these chaotic, we had a plague and then a fire. We're just going to presume everyone is lost at sea. And the real reason they do that is so that they can take all that property under administration, because right after those London fires and the Set the KV Act, guess what they started? The Bank of England. That was the intention, because just like they used us as the surety here, they did that first in England to create the Bank of England. And the king took administrative control of all the estates of the citizens within his realm and was then able to use that as the collateral to start the Bank of England. Right? Or as a source of guaranteed taxable revenue to take out loans from the Bank of England. Right? So not to start, because private investors started the Bank of England. It's a private bank. But in order to take out loans, same reason why Congress wanted a 14th Amendment citizen. So they have their own pool of collateral, capital stock, to take out agricultural loans against. Right? So these are the presumptions. So all title to land, and so the way under the Set the KV Act, if you read it, the way that you would prove that you were living was an action at law in the court of what was called the Court of Wards and Liveries originally, and then it became called the Court of Wards. And you would go and you would sue your guardian. You would sue your guardian, right? Or you would sue the administrator. If you were presumed missing, you'd sue the administrator, and you'd be able to get your estate, right? So this was essentially its probate jurisdiction. And that's how they're doing all this, is probate. Hell, down in Georgia, the
successful at it. I'm sorry. And why they were successful at suing for their estate back is because they knew the law. People don't know the law these days.
Nope, they do not. And that's the issue. So let me see what these guys says. Karen Ann Lucky K McDonald says, arguing any form of English is still babble. I'm not sure I understand what that means. You don't want to argue anything necessarily. You want to ask questions and establish your standing as not subject to the territorial jurisdiction of a foreign corporation, which is what the United States is. So Dick Wayne said, when I got my certificate of live birth, I knew what you teach is the truth. I followed Jamie Lee, plain truth, RIP. I used to follow Jamie too. I liked him. He's a solid dude, had some good information for sure. I think it was the biomag stuff he got into that he started stepping on healthcare's, toes. But anyway, you could speculate what happened. Maybe it was nothing. Maybe it was just, maybe it wasn't healthy. So who knows? But yeah. Anyway, the definition of argue is to make clear, Sergeant Frog Dog says. Yes. I did not know that, but that's interesting. I know that we don't want to be arguing anything necessarily per se. In the courtroom, you want to be challenging jurisdiction by asking questions, right? Because when you start arguing with them, you're considered to be in dishonor, right? It's a dispute at that point. You just merely want to, it's a form of conditional acceptance. I'm more than happy to, perform whatever obligations you're trying to place on the estate if you can prove that those obligations apply to me as one of the people of the state of such and such, right? Because
when he tries to answer your questions, you're laying the burden of proof on him, not the other way around.
That's exactly right.
Put the pressure on him.
Yep, that's exactly right. And that's why you ask questions, because though I despise David Lester Straight and do not endorse him as, he's a gatekeeper. He would give you enough truth to lead you in the wrong direction. He basically, in my opinion, get people in trouble because he tells them what they should be able to do. And he's right when he says the power of the people and what the people standing as sovereign and being as king, right? But then he does not tell you what I'm telling you, which is how you return to that. And so people would go out and try the stuff he would say to cops. And anyway, but that is what he says is when you're asking, you're as king. And that's true. And when you're asking, you're placing the burden of proof on the other person. It's also a debate tactic. If you're debating somebody, then you ask them questions to keep the onus of proof on their side of the table. When you make a statement, the burden of proof is on you to prove what you just said. When you ask a question, they have to answer it, right? Or respond with a question, which you just go back and forth. But so with all that said about the record, oh God,
I read on that U.S. clock site. I read further into that, and the lady, it's always a lady that's talking when she's got videos and stuff. Wears a mask and all this stuff. But she said David Lester Straight arrested for driving without a plate on his car, his truck. Also, Anna Varetz got whacked for $1 million for back taxes, and she denied paying taxes because she had previous debts that she had cleared up with the tax. So that's kind of interesting. Those two big names there.
And another two. I know Anna Von Reitz is all sorts of confused. And another thing about those two people is they will cite a Supreme Court case, right? Like I'm showing you guys exactly the Supreme Court case, and I'm reading right out of the Supreme Court case. Well, what they would do is they, on their blogs and their websites or whatever, they would cite these court cases, and the things that they cited out of the case did not exist in that case at all, right? But most people would take it on faith, like this person knows what they're talking about, then I'm just going to use this case, and because it's got to be there, and they get lazy and they don't go and verify the Supreme Court case or whatever case law they're trying to use. They don't go verify it, and then they go try to use it in court, and they look stupid. You look like, and then they're like, oh, you're one of those sovereign citizens that watches too much YouTube, and that's the shit that they like to say to you. Now, when you explain what I'm explaining, and you can actually show the court cases where they come from, not even a lawyer can argue with you. I know, because I've had this discussion. Yeah, I've had this discussion with the lawyer, and at first he tried to say, well, that's old law. You're bringing up old law. I said, there's no such thing as old law. I said, what's old law? And then I showed him congressional record, all the Supreme Court cases, and finally he was forced to admit, okay, you're right. Yeah, you're right. This is what's going on. I'm like, yeah, I know it is, dude. So stop trying to bullshit me. And speaking of congressional record, here is another. Okay, let me finish my original point. So, as far as the record, right? So the record is how title to the estate was affected, or title to anything was affected. So when you got that original land patent, right? Then when you wanted to sell your property to somebody else, you would draw up a deed, which a deed means something done. It's an action, right? Something done. Okay. And you got all sorts of different deeds, right? You got land deeds, deeds of sale, like all sorts of different things, right? But this deed would be a land deed. And you write in the deed, you know, whatever so-and-so is conveying this such and such property for X amount of dollars in gold or silver to so-and-so, blah, blah, blah. And you write out the whole deed. And then the sale takes place in front of witnesses. The witnesses sign the deed. Okay. Then that deed goes down onto the county land record. Now the title has changed hands via that deed. That deed now represents the original allodial title. And the whole point is over time, and lawyers hate this system, one, because they can't control it and administer it and tax it and all that stuff, and two, because it's actually a lot of work, because you always have to go back to the original allodial title holder, be able to trace the chain of ownership back to the original owner in order to prove that you lawfully hold this land, right? You lawfully own it. And so basically it was just, and the government wasn't involved. There was no need for government permission to tell you can sell it or how to sell it. No regulations, no nothing. Just you sell it and that's it. And the government has nothing to do with it. It's all done in the private, and you merely put it on the public record to notify the public of the change of ownership. This is how you affect the title to your estate also. And since they presume your estate to be intestate, means without a will, and you are missing presumed dead as one of we the people, and you as chattel, public chattel, have no right to hold title or have any say in any of it as a United States citizen. So you need to get out of that position. You claim your estate on the record, and in your claim, you need to revoke or rescind or basically destroy the presumption that you're a 14th Amendment citizen. And that's where I cite Chisholm v. Georgia. I cite McDonald v. State, House Congressional Record. And another one is good to bring up is, let me see where it's right here. This is House Congressional Record, June 13th, 1967, page 15641, under the heading, the 14th Amendment, Equal Protection Law, or Tool of Usurpation. Well, by now, if you've been listening to this whole stream, you should know which of those two things this actually was. It was a tool of usurpation. Usurping the sovereignty of the states by usurping the citizenry of the states as public chattel. And because the state is only sovereign because the people of that state are sovereign. It's the only reason the state had any sovereignty was because it borrowed a portion of the people's sovereignty, right? Well, now the state borrows a portion of the sovereignty that the federal corporation stole from everybody. And it now comes from the top down instead of the bottom up, right? But this right here tells you that it was unconstitutional. And you want to print just these pages, and just have them at the 14th Amendment's unconstitutional, right? It says that 2/3 vote for the adoption of the joint resolution proposing the amendment. It says the fact that 23 senators had been unlawfully excluded from the U.S. Senate in order to secure a 2/3 vote for the adoption of the joint resolution proposing the 14th Amendment is shown by resolutions of protest adopted by the following state legislatures, right? And then down here, it tells you that 15 out of the 37 states rejected the 14th Amendment, needed a 3/4 majority to be ratified, right? And almost half of the states rejected it, and they still pushed it through at gunpoint anyway. This is the absolute linchpin to their whole thing, their whole plan. And what's interesting is the northern states, at least, the ones who are absolute sellouts, they were complicit the entire time. So the same year that they passed the Civil Rights Act, which was the original 14th Amendment, and the only reason it became an amendment to the Constitution is because once they created that federal citizen under the Civil Rights Act, they're like, oh, we need to make this permanent. It's permanent, so no future legislature can take these privileges and immunities away from these poor black people. Right, that was the idea, and they used the race card to play on the heartstrings of the public and justify creating public chattel. It standardized slavery. They didn't do anything to help the slaves. They just made them public property and then made everybody slaves. So it's important to know how to explain this and prove it. Yeah, and Sergeant Fraud Dog says, never trust AI. Always do research yourself, 100%. Yes. Okay, so what I was saying was that 1866 was the Civil Rights Act. And I want to see if I have the veto messages up. Do I? Organic Acts, Practical Treaties. If I have these veto messages up, this will be cool because Buck Act. And I'm thinking I might not have it up. Be cool if I did. But anyways, in the veto messages, Andrew Johnson, then president after Lincoln's assassination, vetoed the Civil Rights Act of 1866 because he said it gives the federal government the ability to create its own citizen. And it takes away the state, that is a right that belongs exclusively to the states, the right of citizenship belongs exclusively to the states. And the Civil Rights Act it gave the federal corporation the ability to make its own citizen. And that's why he vetoed it. It's right in his veto messages. And obviously they still pass it. Well, that same year, Michigan started registering people to vote directly for the president. Right? 1866 or 1867. It was like within a year. And the reason they did that is because they were registering them federally. They were silently funneling them into the 14th, the new federal citizenship. That's why they were doing it. It wasn't the 14th Amendment yet, but they were quietly just filing people into the new federal citizenship using underhanded shit like that. And then it was the next year, 1867, that they started recording births. Demanded that the town clerk or the county clerk keep a record of births, keep a registry of births. And that, of course, was in preparation to register you as public chattel and then be able to borrow against you. So this has been a long step-by-step plan to do this the entire time, and you have to know how to prove it. And I'm showing you how to prove it. And so this is another one. This, I'm not going to read through the whole thing, but if you have the opportunity to read through it, like I said, House Congressional Record, June 13th, 1967, page 15641 through 15645, I believe is the whole thing. You read it's got Andrew Johnson's veto message. The veto message is fantastic, actually. I might read a little bit of that because right here, this is what he said about the unconstitutionalities of the 14th Amendment. If ever the American citizen should be left to the free exercise of his own judgment, it is when he is engaged in the work of forming the fundamental law under which he is to live. That work is his work, and it cannot properly be taken out of his hands. All this legislation proceeds upon the contrary assumption that the people of each of these states shall have no constitution, except such as may be arbitrarily dictated by Congress and formed under the restraint of military rule. So, I mean, that sums it up right there. And that is still what's going on, right? That's still what's going on. So, very important to get that. So, back to the estate. You claim your estate on the record. Rebutting 14th Amendment citizenship is absolutely key. Obviously, you state that you appoint yourself the executor, right, of your own estate, and the reason you do that is because the administrator. So there's an administrator and an executor. Do you remember what the difference is, Jeff? No? All right. So an administrator is appointed by necessity, an operation of law. An executor, which is the true de jure position of that, title of that office, the executor is appointed by will. You got something, Jeff?
No, I was just going to say I was away from my laptop. I couldn't get one. Yeah.
Oh, okay. No problem.
I agree. I concur.
Yeah. So the executor is appointed by the will of the heir or owner of the estate, and an administrator is appointed because there is no will. So it's operation of law and necessity, right? That a judge can name a special administrator, grant letters of administration to a special administrator, or act as a special administrator in order to maintain and dispose of the property of the estate. And so when you say you're the executor, you knock the judge out of the position of administrator automatically, because there cannot be an executor and an administrator at the same time. They're the same position, just created by two different sets of circumstances. So
you as the heir have authority, and you as the heir have authority to appoint the executor.
Right, and you can appoint yourself. There's no reason you can't.
Yes.
Yeah. Yep. You can appoint yourself.
Proxy settler coming along. Yep.
Right. Exactly. All right. So let's see. So that's the primary crux of this situation: proving the mortgage, proving the indenture, proving that the 14th Amendment is voluntary. So you got all that. Oh, here's a little side note I just seen. It's pretty interesting. I have that pulled up. Hold on. DNC complaint. Look at this. This is for the Democratic National Committee versus the Russian Federation, Donald Trump, all this stuff. Well, the reason that I pulled this up, I was showing the members of the Jurist Society, is because they use first of all, I never even heard of DC common law. It's weird, but
I was going to ask you about that. Where did that come from?
So it would technically be like, you could also call the common law, you could call it like I often call it the law of sovereigns, but you can also call it the law of nations, because think like no one nation being above another. It's how it's the law, outside of the contracts and everything. It's the unwritten law of the way that nations should deal with one another as co-sovereigns, so that is a form of original common law. It's also, between us over here in the United States Republic, because when we won our independence, we didn't create a new law. We kept using English common law, except for we were no longer subjects to the crown. We got our independence or sovereignty, and we became co-tenants in sovereignty, as it says in Shisham v. Georgia. But the interesting thing about this is that they're saying trespass to chattels. So this was about the election interference, and they're literally calling the 14th Amendment citizen chattels. That's what they mean by trespass to chattels. They mean that Russia was interfering with their chattel property, their capital stock, and influencing their capital stock. They're talking about you. That's what the trespass to chattels. That's what they mean right here. So it's a little interesting side note I thought you guys would appreciate. But anyway, the other thing that is going to help you, right? And this is what we're going through in the Jurist Society right now. Not really going to get into it too much on the public stream, just because this is more of an in-depth and very intricate aspect of what needs to be done, that you have to actually spend time, like one-on-one time with me. Like we come up on panel, people can ask, hey, like we all have discussions about this. We make sure everybody completely understands each aspect of this, but you want to create a common law trust. It's a private express trust. The reason being, okay, and this is very clever actually, but this is how the Rockefellers and the Carnegies and these guys protected their property throughout the 1800s and early 1900s, before the corporate oligarchy was really established. How it was established is a private express trust, okay? And the private express trust is protected by Article 1, Section 10 of the Constitution, where it says that no state shall make any law ex post facto, right, impairing the performance of obligations of contracts. So when you create a private express trust, you do not need government permission. You have the absolute right to contract, the natural right to contract, and that is where this stems from, is your common law right to contract. You enter into a private contract with another individual or people, and you create a private express trust. that is not a statutory creature. It's not a creature of the state or created by the authority of the state, and it exists outside of the state's authority. Okay. And so what we're doing in the Jurist Society is we are creating private express trusts to put property in that explicitly cannot be used for commercial purposes. And we're going to eradicate the entirety of the regulatory agencies and their administrative codes under the common law of contracts. So essentially the way this works and what article, and it's been upheld, and especially in this book, Weiss Concise Trustee Handbook, he has so many different Supreme Court cases where this has been upheld over and over and over and over again. It was used by Alexander Hamilton to create the Merchants Bank, the Private Express Trust. It was used to create, what was it? It was like the New Hampshire Land Bank, right? So it's been used over and over again. And what's specifically valuable about it is it's sacred. It's considered sacred, constitutionally sacred. The courts know not to mess with it. So they cannot force you to impair your obligation to your common law contract. It comes before and above anything that they have. So if you have, say, your automobile, which is what we're doing, you say have your automobile in this private express trust. And in the declaration of trust, in the instrument that creates the trust, you specifically write, cannot be used for commercial purposes under, or under no circumstances may this property be used for commercial purposes whatsoever, period. And then when the cop pulls you over for not having a license plate, sorry, man, this thing's held in trust. This thing belongs to a trust. It's trust property. And the trust instrument dictates that this property can never be used for commercial purposes. What's that got to do with you having a license plate? Well, a license plate would make this a license plate would make this commercial property. It would automatically, by virtue of what the license plate is, why it's issued, right, under the Trading with the Enemy Act, would place this property in commerce and would violate my common law contract. And it is a crime and a tort for you to coerce me into violating my obligations to this property, to this trust. And that's just one example, right? And so this is the final. So after you claim your estate, this is what you want to do. Everything that I've taught you guys throughout this stream, you can use to throw wrenches in their machinery and their gears, right? Challenging jurisdiction, understanding that they're administering the property of 14th Amendment chattel, right? Held in trust as collateral for the public debt, and knowing that's the only place that they derive their authority and the only people that they can apply this to, or the only entities they can apply this to, are the 14th Amendment citizen, then you can successfully prove that it's voluntary. And that, in fact, it's a bad deal to be a 14th Amendment. It's an unconscionable contract, because why would you, as one of we the people, I already have my natural right to life, liberty, property, the ability to acquire, possess, and enjoy property and protect property and my family and all that. I already have all these inherent rights, including the right to contract. Why would I exchange those for privileges and immunities created by a foreign corporation in exchange for me giving up my sovereignty, my natural rights, right? Why? It's just a bad deal. It doesn't even make sense. You're not getting anything. They're not actually giving you any kind of valuable consideration for what you're giving them. You're giving them your sweat equity to use as collateral. What are they giving you? Nothing. They're taking things from you, actually. Not only are they not giving you anything that you did not already have, they're taking those things from you. It's an unconscionable contract to be a 14th Amendment citizen. And by virtue of its unconscionability, it's void ab initio from the beginning. Who in the hell would ever, well, again, it was the newly freed slaves who could not take care of themselves because they were in a state of dependency. So they could not exercise, they could not have lawful right to property or enforce that lawful right to property because they didn't know anything. It had to be But even Andrew Johnson, in his veto message of the 1866, he says this Civil Rights Act purports to give federal citizenship to, blacks and Native Americans not belonging to one of these nations, et cetera, et cetera. He says, but it's unnecessary because in time, he says the blacks have just now become free. He said now they have to learn how to be free, and in time they will be able to act as the rest of the de jure people act and exercise their natural unalienable rights. We don't need this federal class of citizenship. So it was only ever created to create capital, to allow Congress to have its own capital stock of collateral to borrow against. And when you know how to attack that right there is step number one, and prove it. Right? Don't get there and say, well, I'm traveling, I'm not in commerce and all that stuff, because here's the thing. If you've got the license plate on your car, then you're automatically presumed to be in commerce. 14th Amendment citizens are only... Go ahead.
I was just going to say that's his attachment. That's all he really needs. He doesn't need to see your driver's license if he's got that license plate.
That's right. And the name of the game for him is to create an attachment to the underwriting trust, to the actual surety. The Social Security represents your productive value. That's why all your important property is tied to it. He needs to create an attachment to that trust account in order to generate his own currency. That's what they're doing. These courts are acting as unregistered bank. They're basically unlicensed banks generating unregistered securities, like a fucking casino.
Yeah.
Right? They're just like a casino.
Yes.
Yeah. The way that a casino issues
they're always going to win.
Yeah. Well, but even the same way that the casino issues chips and creates its own currency, right? That's what these courts are doing. And then they want...
Yeah, and then...
Go ahead.
I was going to say in Las Vegas, I believe a chip is as good as cash, too. As far as you go to a restaurant or whatever. Yeah.
Yeah. That's what I mean.
Just a microcosm. Yeah.
And these people are creating, that's what these banks are, or these courts, these banks pretending to be courts, they're generating their own commercial paper, which is currency. Because the Federal Reserve note is just a contract evidencing a debt and secured by your productive value. According to
two signatures from the...
Right.
With two signatures, one the Secretary of Treasury and the other the Treasurer. One IMF, one US.
Yep. And I do want to address this for Scott real quick. He says, when someone says sovereign citizen, aren't they contradicting themselves? Okay, so that's why I usually don't get into this too much, because not in our republic, no, because the state citizen comes before and exists above the government, just like it says in Chisholm v. Georgia right here. It tells you that, right? Joint tenants and sovereignty, and that the government stands in the same relationship. Let's see, governors are agents of the people and at most stand in the same relation to their sovereign, meaning we, the people, in which regents in Europe stand to their sovereign. So they're basically like a vassal. They're our servant. And so the citizens, and the reason that the citizens are sovereign in this instance, when you're talking about the people of the state, because you didn't even have to be necessarily a citizen unless you wanted to participate in the functions of the state. You could just be an inhabitant. You still have all of your common law unalienable rights. That's been upheld by court case after court case also. But the state citizen is the creator of the state. So the state is the citizens. That's what a state is. The government is the servant of those citizens, right? The citizens created the state, and therefore they're above it, because the creator can never be subject to the created. That's a maxim of law. It's how it works. And so, at least not just automatically. Like, obviously, if you become dependent on it, like we said, and you fall into that pauperism, come under administration, then whatever. So I usually don't say state citizen or anything like that, just because it confuses people. And sovereign citizen's an oxymoron. You definitely don't want to use that term with a cop at all, because they're trained to, that's a red flag for them, and they're immediately going to get hostile, right? But in this instance, yes, the state citizens are actually sovereign. And this right in a court case, so that I'm showing you. The federal citizen is a creature of the corporate state, meaning it was created by the corporate state and therefore is subject to the corporate state. So, as we, the people, we come before government, and government only exists essentially at our mercy and at our pleasure, basically by our pleasure. So hopefully that answers your question. I generally just say yes, sovereign citizen is a contradiction in terms. But in our original structure under the Articles of Confederation, it is not a contradiction.
That's right. I would prefer to be called one of the people of Texas.
That's what I said too.
So, yeah.
So when I'm talking to the copies, I say I'm not a 14th Amendment citizen. Oh, you're not? What do you tell you? It's like, yeah, I'm not a United States citizen. I'm one of the people of the state of Michigan. So I say, well, what's that mean? It means that my property's not under administration. I'm not under your foreign jurisdiction. This commercial jurisdiction, this extension of Congress, right? That you've just cast like a net over the entire nation using different, jurisdictional overlays like social security zones, zip codes, stands for zone improvement program, part of the Reconstruction stuff, the Federal Reserve districts. There's a multitude of different jurisdictional overlays, but that's why, just like it says here, and resident defined by the Michigan Motor Vehicle Code. And I'm going to show this one more time for everybody's benefit, just because this is so important to understand, to fully grasp, right? So that the term, so it says a member of a state may be either a citizen occupying the status entitled citizenship, or he may be a resident alien occupying the status designated by the title, where are we at here? Occupying the status designated by the title residence. That's why your governors call you residents, because you're a foreigner. A citizen is a permanent member of the state, owes its allegiance at all times, and is entitled to its permanent protection, whether he is at home or abroad. Status of his membership, citizenship, is distinguished by its permanent and personal nature. Okay, as opposed to a resident alien, on the other hand, is a person residing within a state other than the state of which he is a citizen, right? And the status of his membership, residence, is distinguished by its temporary and local nature, and it's temporary and exclusively for the purpose, in the case of the 14th Amendment citizen, exclusively for the purpose of engaging in commerce. And that's why everything you do is commercial as a 14th Amendment citizen. And so right there, you see that resident means foreigner, right? And then we pop over to the Michigan law, and it shows you resident defined, and it says the same thing. It says resident means every person who resides, again, that's temporary and local, right? Resides in the state and establishes that he or she is legally present in the United States, because you could not be physically present in both Michigan and the United States at the same time. You could not, right? And the reason being is because the location of that debtor is the District of Columbia. Location of the United States. The United States is located in the District of Columbia, UCC 9-307, right? So you cannot be physically present in both Michigan and the United States territory. You have to establish that you're legally present in the United States, and you do that via contract, whether that be your driver's license or what have you. That's why they need that license. They need that license plate, because that right there establishes your legal presence in the United States territorial jurisdiction. Remember, one may be a citizen of a state and yet not a citizen of the United States. Right here, very important, because the only way that you could actually be subject to the United States as one of we the people is if you sojourn as a resident to the District of Columbia. Now you would be a resident because you're one of the people of the states and you're here within the District of Columbia. temporarily. And notice how we cage this thing in with boundary stones, right? And on one side of the boundary stone, it tells you jurisdiction of the United States. So it's telling you as you're walking into the District of Columbia, here, now you're under the jurisdiction of Congress. Now you're under the jurisdiction of the United States Corporation. And then when you're leaving the District of Columbia, i.e. back into Maryland, it just says Maryland because it denotes common law jurisdiction, right? So now you're back under common law jurisdiction when you walk outside of this cage. And we caged it in because we knew, or the founders knew, that it was going to do exactly what it has done and spread its tentacles like a frickin' Leviathan outside of this little 10 square miles and ensnare the entire republic in a commercial net. That's exactly what it did. It's exactly what it did. This is what you attack. Go ahead.
And being a legal person of the United States, that to me applies to the estate, the ens legis that you haven't claimed, because legal is not lawful and lawful is not necessarily legal. That's a Blackstone statement, I think.
No, it's 100% true. In fact, okay, here's a good example.
We want to be under law, not legality. Color of law. That's why they call it color. Like hue man, color of man. Same thing.
Here's an example of something that's legal but entirely unlawful, and that would be the use of Federal Reserve notes.
Correct.
Right. So they legally made it the legal tender. It says it right on there. This note is legal tender, right, for the payment of all debts, public and private. But Article 1, Section 10 clearly says that no state shall use anything but gold or silver as legal tender in the payment of debts. That's the law. That's the law of the land. The compact that created the republic is the law of the land, and which is one of the reasons why when you create a private express trust, you're going back to the original law of the land, which is common law. It's the law of the land, and using Federal Reserve notes, because it specifically prohibits negotiable instruments. It tells you this is right here, Article 1, Section 10. Let me see here. Yeah, right there. I'll do that. Article 1, Section 10. Specifically, that is. Oh, so the Article 1, Section 10 doesn't exist anymore? How about that? All right.
Yandex it. The Russians got it all.
Yeah, right. Yeah. So, hold on. Article 1, Section 10.
There we go.
No state shall, without the consent of Congress, lay any duty of tonnage, keep troops. Okay, that's not it's the second part. Okay, the first part. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, which is basically legalized piracy. That's actually what these cops are. There it is. Coin money, emit bills of credit, right? That's what Federal Reserve notes are, bills of credit. Make anything but gold and silver coin a tender in the payment of debts. So there's to illustrate your point. It's legal to use the bills of credit as legal tender, but it's entirely unlawful to use bills of credit as tender.
Right. Because tender means tied up to. So when you use a contract to tie up to, it's just a form of debt. It's debt chasing debt.
That's right. Yeah, and you can't buy or own it. It forever locks you into equity, because remember, the law that you're under is determined by your relationship to your estate. So when you have the absolute title to your estate, to your property, which means there would be no title, you're just free, because you don't need a title unless you're going to split it, right, to something intangible like your property rights, unless you're going to use it as collaterals. The only reason that you would make a title, which is why they made a title called the birth certificate, so they could mortgage it. But when you have your property rights and you're under the law of the land, then you are sovereign. Now, if you're under administration because someone has a superior interest in your property, whether due to a contract and debt or the fact that you're a pauper and accept benefits or whatever the case may be, if somebody else has a superior interest in your property, then you're under administration. You're subject to the will of that person whose administration you're under. It's that simple. Now I say that because, or I bring this up because when you're under administration, the reason they wanted to trap everybody under administration is there's two different jurisdictions, primary jurisdictions in this republic. Let me see if I have it pulled up here. It's 28 USC 9-307. I swear it had it pulled up. It's Article 3, Section 2. Somewhere. It's Article 4. Huh. Can't believe I don't have it pulled up, so I'll just pull it up real quick. How's that sound? Article 3, Section 2. Now, before I even debate anybody on law, I've made up my mind that you have to be able to answer this question. Otherwise, it's a waste of both of our times. And so that goes for anybody who'd be interested. Oh, we got the true few over in the chat. Good to see you. So Article 3, Section 2 of the Constitution, it says, and now this is important, the judicial power shall extend to all cases in law and equity. Notice how they're both capitalized. Now, equity is not law. Law is not equity. Law is law. Man does not create law. Law is not written. It can only be written about. Equity, on the other hand, supplies for the deficiencies of law. Equity is the enforcement of trust arrangements, contracts, agreements, and then also those instances where there's an implied, where you believe there's an implied trust created by, like, say, I save your property and it wouldn't exist without me, and now I can claim to have a right to some sort of equitable relief from you for saving your property. I would take that to a court of equity because law wouldn't even begin to look at that. That's all imaginary. It's all construed by my human reasoning and my perception and perspective. It's not actually law, right? Same thing
and
with
presumption.
Why
Presumption
trust
is a really good word.
why trusts are always only adjudicated in equity because the law will not recognize fictions. It cannot deal with imaginary rules and things that are not actually law, right? Imaginary personas and imaginary rules. So all of that has to be adjudicated in a court of equity. And in the court of equity, the judge is God because the judge has to decide according to his conscience what's fair according to the trust arrangement or contract or whatever the case may be that's before him. And he's able to determine that because it's not law. So he's not technically acting as God when he's actually in his proper capacity. But when they've pulled everybody into trust, right? When they've pulled everyone into trust, Sergeant Fraud Dog, I'm only bringing this up to show the difference between law and equity. I know that it's not getting into the Article 1, Article 3, and all that right now. But the reason they pulled everybody into trust is because trust can only be adjudicated in equity. So when you have actual ownership of something, you have lawful property rights that you can enforce at common law. That's what lawful means. Now, if you only have a privilege granted via contract in some property, and the property is under privity, meaning more than one person have interest in the same property, then your rights are equitable and they're determined by the provisions of the contract that gives you interest in it. And so you have to take and enforce those equitable rights in a court of equity. So what they've done by making you a trustee of your own estate and removing your access to lawful money is they permanently locked you into the jurisdiction of equity, where the judge is God, where the Bar Association can be God, and they can decide whatever they want. They can even decide to go against the jury in a court of equity because it's not law. Okay, so I'm gonna staple this home, and then I'm gonna shut this down here momentarily. But I want to really drive this home with Blackstone's commentaries. Hold on, let's see here. I'm going to have to search it because we're still stuck in the equity. So we'll do law without hopefully it'll pull it up. It's a pretty big book, but this is going to illustrate what I'm talking about equity. This is Blackstone's commentaries, right? And essentially what he says, because it's going to take forever to search. There we go. Nope, not there. Cannot be common law. Law without the word heirs. Bear with me, guys, for a second. Equity. Oops, you gotta have space in there. Law without equity. So what he says is that law without equity, though hard and disagreeable, is much preferable to equity without law, right? Because equity is essentially the judge's conscience. So he's getting into feudalism here. Either states, so it's not coming up. All right, let's try to search it this way. Let's just do equity. Or no. Hard and disagreeable, maybe? See if this pops it up. But it's very, very important. One of the most important things you can know is the difference between law and equity, because then you can ask, is this a court of law or is this a court of equity? And it's always a court of equity, because you have no access to law because they took away all the lawful money. So there is no law in the country anymore. Wow, it's just not even pulling anything up now. This is ridiculously stupid. What the hell? Huh. Well, anyway, you guys can take
I kind of look at law as a line in the sand, and equity is a buffer zone on either side. And it's up to somebody's judgment to say how far you can cross over that line.
Right. Equity is generally, I try to keep it simple for people. It's like, that's a simple way to look at it. And then another way to look at it is just essentially equity is the enforcement of prior agreements, like nisi prius, basically. It's
right.
It's the enforcement of a trust arrangement or the enforcement of some other contract, or like I said, it could be maybe I am trying to construe an implied trust based on either your action or mine, and I'm trying to get that implied trust recognized. Then I would take that to a court of equity and appeal, or it's called praying or appealing to a chancellor or a judge in equity, because chancery and equity are almost exclusively the same thing also. So, but so hold on. Power to establish uniform rule of naturalization, title of nobility. Okay, so this is like, it's getting into how it applies to the Constitution. Vested in one Supreme Court, Judge Story, judicial officers. Yeah, I do not know where that one section I want to find, but I'll bring it up next time for sure, because it's very important. It's one of my favorite quotes. I know I have a screenshot saved of it, so could always just see if I could bring that up too. But anyways, he says equity without law, or law without equity, though hard and disagreeable, is much preferable to equity without law, essentially because you'll have as many different rules of procedure as there are variations of consciences of men, is essentially what he says, because equity is entirely up to the breast of a judge. It's discretion. When you look up discretion in Bouvier's Law Dictionary, he basically says it's the equitable conscience of a judge, and he also says it's the law of tyrants, because basically you're subject to the judge's capriciousness and vice and folly. And so it generally manifests as the law of tyrants. Well, that's why they wanted everybody trapped in equity. When you have that social security number and you are the trustee of that trust, all your property is tied to that trust as collateral, and you only have equitable rights to any of the property as determined by the various contracts required for you to use the property, like a license, for instance, to use the automobile, which makes it a vehicle, commercial, right? And that licensing contract demands that you adhere to the motor vehicle code, right? So and that's, you have equitable rights that are subject to those equitable duties. And that's not actual ownership. That's usufruct. That's usury. It's basically usury of property as opposed to money. It's charging interest on property as opposed to money. That's what usufructuary is. A usufruct is. It's the same thing as that's why the word use is in it. It's usury. So that yeah, that's important to understand. You do not want to be in a court of equity. So anyway, all right, guys. Do you have anything you wanna add on this before I shut down, Jeff?
No, just enjoyed it. It's very informative and a lot of stuff that I knew. But boy, if anybody's going to get serious about this, join that Jurist Society. I'm telling you, it's intense. It's fun, a lot of fun, and it's really strengthened my faith in God. And that may sound funny to people, but like you said a million times, the Bible is basically a big trust indenture, and it is.
Yeah, and all trust law, all law is stems from the Bible. I agree with you, Jeff. Same thing with me too. Is my study of the law has brought me much closer to God as well. And you know, you really understand the various scriptures where it talks about people who work iniquities and who have no respect for the law, what that actually means, because there is only one law. There is only one law, and it's always been that way. And everything else is just man-made rules regarding, you know, or regulating the use of property or regulating commerce. That's it. That's all. That's the only other, and those require your consent to be under them, right? Whereas you're always under the Creator's law. So, yeah. And in the Jurist Society, we learn how to. We are learning how to create the private express trust. Many of us have already claimed our estates, including myself. I know, Jeff, you say you're working on it, right?
I'm real close. I just got to put the finishing touches on it because like I told you, I was wanting to go a little bit deeper, but I don't think that's necessary because I can always amend it, right?
Yes. Yep.
Claim?
And it's
okay. Yeah, I might just get what I got and go for it.
To amend it, it's as simple as you know, you write a public record and say, you know, this public record is to amend public record, and then you write the original public record down on that record and say to read as follows, and then you can just put the amendment on the record, and it will amend the original document to read as follows in the new amendment. You know what I mean? It's that simple.
Mm-hmm. Mm-hmm. Yeah.
So but yeah, and man, you guys just, this is the most, I know it seems like beating a dead horse here with this 14th Amendment, but this is the Jenga piece that if you pull it out, their entire system collapses. And I cannot stress that enough. And you have to learn how to prove how it's voluntary, how to rescind or revoke the presumption, you know, to destroy the presumption that you are a 14th Amendment citizen. You have the right of expatriation. They passed that right before they did the 14th Amendment because they always have to give you a way out. Otherwise, they're violating your free will. It's just like, you know, they're satanic rules or whatever. It's how they absolve themselves of karma, but they always have to give you a way out. They did that with the Expatriation Act of 1868. Okay, and it basically says that to not allow somebody to expatriate would be inconsistent with the fundamental principles of this republic, right? Because you are essentially forcing someone into slavery if you're forcing them to be chattel for the public debt. And they're not actually accepting any benefits from the public debt, or at least not without, you know, being under duress and coerced to do so. You have the right to expatriate. That's what we do when we file our claim. Part of the claim is expatriating from federal citizenship. Therefore, when you serve the claim to whoever, because the claim is also a performance contract, that's how we set it up. It's a performance contract where when they continue to administer your estate after you've served them with the claim and let them know that the estate's not under administration, then they, by tacit agreement, which just means by their continued action, consent to be a trustee under your administration. And they give power of attorney over to you and all that good stuff, right? And so Yeah. And so when you serve them with this, you literally take away all their standing to try to act as a special administrator of your property, regulate your property. And that's what you need to do. It's so important. But even before, or if you decide not to file a claim on the record, which would be ridiculous because it's literally the only way to not be under all these presumptions. If you decide not to file your claim on the record, at least learn how to explain everything that I've been saying throughout this whole presentation, because there's nothing they can only end up just being belligerent and committing a crime against you once you prove without a doubt that United States citizenship is voluntary, that to force somebody to be public chattel is slavery, and you prove that's exactly what they're doing. What are they going to do? What can they do? Right? So with that, guys, I appreciate you, Jeff, as always. I appreciate the audience. Let's see. Yeah, I may stream tomorrow. I think I'm going to pick up on the law and equity thing, because that's very important, and that's another tactic that you can use to challenge jurisdiction right at arraignment. And that is this a court of law?
Really,
right?
pretty simple. It really is. It's really simple.
Yeah. It's simple to you because you understand it now, or you get
yeah.
the.
It wasn't at first. That's true. Yeah.
Yeah, it's a little
Once
confusing.
you understand it, it's very simple.
It is. Yeah, it's like, hey, is this a court of law or a court of equity? And they'll try to lie to you. They'll be like, well, it's a court of law. Oh, okay. Then where's the victim? And where's the signed sworn affidavit with the witnesses that injured somebody? Where's that? Oh, well, you're here because you didn't have a license plate. Oh, so it's not a court of law then. It's a court of equity. All right. Well, where's the agreement that you presume me to be under that requires me to convey the right of my property to the state to be used as collateral for public debt? Where's that at? Because there's got to be one or the other. Can't just have me in here on nothing. And you'll be what they consider a vexatious litigant. Right? So.
Is that a good thing?
Not for them.
No, not for them. Yeah, I kind of think that. Okay. Well, thank you, Ryan. Check out of here. Better, Mojo, if you're still around.
Yeah, later, Mojo, Sergeant Frog Dog, True Few, Scott, Dick Wayne, anybody else who may be in the chat still. And I will see you guys either tomorrow or the following day. Have a good night.
All right.